Right. Yeah. Well, that's enough fun. You've enjoyed the last bit, and you know, into every life a little rain must fall, and I am that. I am that rain. I'm a lawyer. I'm sorry about that. But one of the things one needs is obviously you need criminals and you need people who don't get it right, because otherwise people like me wouldn't be able to pay our mortgage. So that's fine. Anyway, the reason I think I'm here is because I wrote an extremely dull book called The Control of Outdoor Advertising and Graffiti a few years ago. About 20 years ago I wrote the first edition, which was then just called The Control of Outdoor Advertising. Spot the difference. The bit about outdoor advertising has hardly changed at all, so and graffiti has changed and is still changing. And indeed, this, although it was only written about 5 years ago, the bit on graffiti law is completely inaccurate and out of date. So don't buy the book. But what it does show, though, is that it shows where several things come from the title. One is that lawyers are obsessed about control, not advertising and graffiti. What the law is there to deal with is how you control things. And also that graffiti is very much an offshoot of, or the law on graffiti, in this country at any rate, is very much an offshoot of the law on outdoor advertising. So that's why I'm looking at the law on graffiti, and particularly the changes that have come through in recent years. I start though with just a brief reflection on the role of law. You know, what's the point of the law? Why do you have the law? And we actually had, I think Barack was mentioned a few minutes ago, and much of the time he said in his book, before he was president, much of the time the law is settled and plain, but life turns up new problems, and lawyers, officials and citizens debate the meaning of terms that seemed clear years or even months before. For in the end, laws are just words on a page, words that are sometimes malleable, opaque, as dependent on context and trust as they are in a story or a poem or promise to someone. Words whose meanings are subject to erosion, sometimes collapsing in the blink of an eye. That's how you get elected as president. The law, in other words, it's there trying to sort of control things that are changing. Things, some things are very much the same and have been for years or decades or even centuries. Criminal damage, for example, is obviously a good example of something people have for years had the idea of criminal damage. If you do things to other people's property, and note the link back to the previous speaker, or the speaker after lunch, who she was saying a lot of this concern about graffiti is about concern about damage to other people's property rights. But the concept of law controlling damage to property has been there for decades. But what I'm looking at is not so much that, because that's fairly obvious, that if you do damage to people's property, then you get nicked if the police catch you and then you go through the criminal procedure. I'm looking at specifically this afternoon at the law that particularly relates to the control of advertisements and graffiti, as opposed to general property damage. So the starting point, therefore, is the control of advertisements. What is an advertisement? And how does it get controlled? Note the emphasis on control. And what is an advertisement? Well, it's pretty nearly everything. It's signs. It's well, in fact, to be specific, it's any word, letter, model, sign, placard, board, notice, awning, blind, device, or representation, whether illuminated or not, in the nature of and employed wholly or partly for the purposes of advertisement, announcement, or direction. Does that include graffiti? Not sure. I suppose it's an announcement, don't know, maybe advertisement. And so it certainly includes an awful lot of boring stuff like roadside billboards and traditional advertisements, posters, signs at petrol stations, and millions of other things. That's the bit that's been basically settled since more or less the end of the Second World War. Lots and lots of detailed changes, lots and lots of tweaking, but basically you need to get consent to put up an advertisement. But graffiti has been the subject of legislation recently. It was covered first of all in London, the London Local Authorities Acts in 1995, 2004, 2007, and again note that the fact that there are different acts coming faster means that somebody somewhere thinks that there's a problem. Then it got rolled out to the whole country in the Antisocial Behaviour Act of 2003. Again, note the antisocial behaviour, not planning. Then the Clean Neighbourhoods and Environment Act. What a wonderfully politically correct title that is. In 2005. And then it got put into the Town and Country Planning Act by the Localism Act of 2011. So you notice there's that quite sort of, there's been a stream, nothing from 1945 where the planning system started, right through for 50 years until the London Local Authorities Act, then first in London, then expanded to everywhere. Everywhere in England and Wales anyway. And so that means that it came in originally as antisocial behaviour. Now it's part of the Planning Act. Now that may just be convenience for people who draft Acts of Parliament. They have their own ways of doing things. Or maybe it's no longer perceived as part of antisocial behaviour and it's now part of the way we plan cities, the way we actually do things positively. That the control of advertising, and in particular graffiti and fly posting, is seen as part of the general task of planning for cities and towns. And in the control of the details of advertising control are all in the 2007 regulations, which is entirely to do with billboards and doctors and dentist signs and petrol stations, so forget about that. But you just need to know it's there so you can forget about it. But the basic principle of how the law works in this country is if you are going to put up an advertisement, and as we've seen that covers a very wide range of things, then you need either deemed consent or express consent, and you've got to get one or the other. The regulations I mentioned, they give consent for all kinds of trivia, for brass plates outside doctors, for shop signs, for all sorts of things which are signs and advertisements on a very routine way. But if you've got something bigger than that or something unusual, then you need express consent. And that's a bit like planning permission. Indeed, frequently High Court judges talk about planning permission for advertisements. What they actually mean is express consent, but hey, they're only judges. But the key thing is that the person doing the advertisement needs consent, either automatic consent under the regs or express consent in response to an application. And if you put up an advertisement that hasn't got consent, you are for the high jump. And you are technically liable for two things. One is you're liable to have it removed, and the second is you're liable to be prosecuted, and if you get caught, convicted. Clearly, by the nature of the thing, graffiti and fly posting tends on the whole to have neither form of consent. There is no category of deemed consent covering graffiti and fly posting. Take it from me, there isn't. Obviously, no one is going to get express consent for some of the things we've been seeing on the screen, or at least they haven't hitherto. Whether they will, whether once you've got, the nearer you get to street art rather than graffiti, if that comes as an advertisement, maybe people will apply for consent and get it. And all your consents, whether it's deemed consent or express consent, comes subject to a number of standard conditions. And one of those conditions is, surprise, surprise, that you must have the consent of the owner of the property on which you're doing it. And another condition is that the property must be kept in a neat and tidy condition. Two nice, boring, middle-class conditions, because the law is written by neat, tidy, boring, middle-class people who live in Pinner. And so, boy, you live in Pinner. I'm very sorry to anybody who lives in Pinner. But the standard conditions, basically what they're saying is the world needs to be tidy and ordered and orderly, and if you haven't got every advertisement, whatever it is, it must be subject to the standard conditions about consent from the owner of the property and condition. And if you haven't got those conditions sorted, you are breaking the law and you've got a criminal offence potentially if you get caught. And that immediately brings in problems in relation to graffiti and fly posting. There are various powers available to planning authorities to get rid of advertisements. I mean, you can prosecute the people responsible, and yes, if the person responsible for an unauthorised advertisement is a big multinational poster company, you know who they are, you can prosecute them. That's easy, or relatively easy. But usually the problem is not so much to prosecute those responsible, it's to actually get rid of the advertisement. And if the advertisement is in fact graffiti or fly posting, it's probably very difficult, if not impossible, to prosecute those responsible because you can't find them, fairly obviously. I mean, you may be fortunate in knowing who it is who did it, and some of the more notorious ones we've seen today, and you will no doubt be seeing tomorrow and the day after, everybody knows who's responsible. But my memory is that it's quite difficult to find these people. The one thing I've noticed when I wrote that book, I think every review of the book, and anyone who I was talking to about it, I think every single time they mentioned Banksy. And they all said, but will that outlaw Banksy? Will Banksy be caught? Will he be prosecuted? What do you do with the Banksy thing? How does the law fit with Banksy? And the clear implication of everybody's comments were, it doesn't really work for people in that category. The law simply doesn't fit terribly well. The law is designed, I mean, if one takes the dichotomy of street art versus graffiti, which we were hearing earlier, is arguably not helpful, but I'm going to do it anyway. Then the law is aimed at graffiti. It sort of cunningly sidesteps the question of street art. We'll see in a minute. But so you have the local authorities have powers. And they note the word power. They do not have duties. Local, they don't have to do anything about any of this in terms of unauthorised advertisements. They merely have powers. And what that means is that they can just get on and they can go on to private land, they can do various things, they can prosecute people, they can remove advertisements and so on. First thing they can do is to remove or obliterate posters or placards. Second thing they can do is to remove structures used for displays, things like billboards. Thirdly, they can remove pictures from trees and highway structures, which might be getting closer to graffiti. And then fourthly, they have graffiti removal notices. And you can tell from the cunning 225C, that's one of the bits that they've added in later, because it was originally at 225, and then A, and then B, and then now C. And that's the most recent of the various powers available, and obviously the most relevant in the present context. Graffiti removal notices, as I was saying earlier, used to be available in London now, then throughout England and Wales, and now throughout England, because they used to have for a short while a rather awkward period when they had one set of powers in London and one in England and Wales under the Anti-Social Behaviour Act, and they were pretty similar but not quite the same. So they said, okay, fair enough, we will introduce, in the Localism Act, they introduced the section 225F to 225K, again, note the kind of shoehorning it in sideways, and they've introduced it throughout, the same set of powers throughout England. Spot the mistake. They forgot about Wales. It appears that the old rules used to apply in Wales, the new rules apply throughout England, but not Wales. So if you want to do some really creative graffiti, I'll leave that thought with you. You may also wish to refer to the Welsh Language Act, which makes it more difficult. Because any public announcement in Wales probably has to be in English and Welsh. Whether that would apply to tags, I'm not sure. But anyway, so then we have government guidance. Government guidance is issued by people like Sir Humphrey Appleby and is very sensible and safe, and therefore not perhaps quite of as much utility as one might hope for. In other words, it's pretty well useless. Defacement removal notices from DEFRA was a useful guide. These are obviously available on the web. Came out in relation to the Antisocial Behaviour Act, and is actually still quite useful, except of course it applies to the wrong legislation because it's been changed in the Localism Act, but the principles are quite sensible. And there's quite a helpful graffiti removal code of practice from the Association of London Government, issued in 2005, which is quite helpful, to be fair. And contains various things. That is to say, when I say helpful, helpful if you are a local authority trying to remove it. I suppose it's secondarily helpful if you are somebody trying to resist a local authority trying to remove it. But that's the way it works. The third one is the most recent planning practice guidance in 2004, which really is useless because I think it's about one paragraph in the middle of several hundred pages of stuff about all sorts of other issues, and so virtually useless on graffiti. But what the government guidance that there is, particularly the DEFRA guidance and so on, and the London guidance, it does emphasise that these powers should be used sensitively and with a sense of priority, and in particular they should concentrate on graffiti and fly posting that is offensive, particularly, of course, if there's a racial or anti-religious element to it, because it's causing social problems, as well as maybe aesthetic problems. If you want to serve a graffiti removal notice, you can serve it in relation to any sign. Well, what is a sign? A sign is any writing, letter, picture, device, or representation, but not any advertisement. Which is interesting because you may remember, if you were awake, that the definition of advertisement included any word, letter, model, sign, placard, board, or notice, or device, or representation. So I'm not entirely clear what a sign is. So I think we may have problems there. It remains to be seen. I'm not aware that this provision has yet been tried out in the courts, and so I don't know what anyone's going to come up against, but I have a feeling an enterprising graffiti artist might be able to say, what I have done is in fact, because it's a writing, letter, picture, etc., 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 it is an advertisement, and therefore the act is completely meaningless. On the other hand, if you think of the sort of people who are likely to administer any prosecution, viz. The magistrates in the Bracknell Magistrates Court, I think they would regard that as not a terribly sensible submission. I think if they actually manage to have a graffiti artist in front of them, as we were hearing earlier, they will be delighted to make an example, and pettifogging stupid arguments about the meaning of sign will go straight out of the window. The Court of Appeal, on the other hand, might take a rather different view. We shall see. So it's got to be a sign, and secondly, it's got to be detrimental to the amenity of the area or offensive. Therein lies the heart of the whole thing. What is that? Interesting point. We'll come back to that perhaps at the end. And thirdly, boringly practical, it's got to be on the surface of any premises, apparatus or plant, and readily visible from a place to which the public has access. So provided it's visible from the park, from the street, from a railway line, you can serve a graffiti removal notice. But not if the sign is on the operational land of a statutory undertaker, that's to say railways, electricity boards, etc., etc., the people like that. And if it's a post office land, you've got to give them 28 days notice. Don't know why. The law is very strange. So basically, the reason for that was because the statutory undertakers put in a lot of pressure when bill was going through Parliament, saying that they needed special treatment because actually you can't have local authorities crawling all over statutory undertakers' land, which is understandable because if you, a moment's thought, it's particularly obviously railways, but also power stations and such like. If there may well be graffiti on signal boxes and on and places of that kind, but the railways are not terribly keen to have local authority enforcement officers crawling all over the signal gantries over the main line into Paddington, which is understandable. So if a local authority wants to deal with that, they have to do it by negotiation and agreement. And what the local authority do is they serve a notice on the owner and occupier of the land. They must tell the recipient, who will be the owner and occupier of the land, not of course the person who did the graffiti, to remove it within a specified period. And so it could, for example, require repainting of the whole of the surface or just the part directly affected. So what it will say is your house, your gable end wall, your structure is covered in graffiti. Will you please sort it? And either sort it by doing this or by doing that. If not, we will come in after 15 days and do it for you. You can appeal against a notice on the grounds that, firstly, the sign is not detrimental to the amenity of the area or offensive, which is obviously where the fun will start. And then, secondly, the boring ones, that there's a mistake in a defect in the notice, or the time for compliance is too short, or the notice should have been sent to somebody else. Those are kind of standard boring ones. But ultimately, it comes down really to there are two key questions. The second and boring one is, how can those responsible for such displays be identified and brought to justice? I think that's one not for the lawyers but for the police. But the first one is a more fundamental question, which is what advertisements, and in particular in the context of graffiti, what graffiti, are offensive or detrimental to the amenity of the area. Obviously that's something which you will be talking about for the whole of the 3 days. I don't know. I mean, offensive, the sort of thing that's offensive to the chairman of the bench in the East Berkshire Magistrates will be pretty nearly anything. But is it really offensive? I mean, if you had a UKIP advertising poster, would that be offensive? I mean, yes, no. I mean, you know, one can think of arguments going either way. What happens if you had a UKIP, sort of pro-UKIP graffiti on a wall? Would that be offensive? Or would it be helpful political advice on how to cast your vote in the general election? Don't know. I think that might be quite a tricky one. And of what it might be offensive, there are cases which talk about what might be, in the context of the law of nuisance and noxious smells and things, what might be offensive in Bermondsey would not be offensive in Berkeley Square. Would that apply to advertising? Might do. But then you're into a tricky area of posh, nice middle class bits of London where almost any display is offensive, and back streets around the back of, I don't know, wherever, Shoreditch, where who cares? Don't like that terribly as an approach. And of course, what is detrimental to the amenity of the area? Then you really are into tricky territory. Probably, since in order for a prosecution to succeed, it's got to be shown that there's a detrimental to the amenity of the area. The benefit of the doubt would therefore have to go with somebody who says it is. Sorry, the benefit of the doubt would be in favour of the defence. So if the defence, that is to say the artist, says, but it's wonderful, it's lovely, it's beautiful, everybody thinks it's splendid, and the boring local authority say, no it isn't, it's detrimental to the area, we're in East Berkshire, get real. Then probably the benefit of the doubt would have to go to the artist. Again, though, just think about it, is that really going to work in Bracknell? I suspect not. So I think there are sort of problems. I think the bottom line is I suspect that there is a huge problem. The sort of people who write laws are all on the side of the controllers, not on the side of the creative, and so maybe that's where we are, which is sad, really. I mean, I don't know. Do I hate graffiti? I'm not sure. But I thought that was a nice one. I saw on a wall a few years ago. That I first saw the first one, and then about a week later came the second half, which I thought was rather nice. Right, okay, enough.